So I am thankful to the bench, my lord, for giving me an opportunity to address the bench, my lord.
Yes.
And my lord, in my humble submission, the reference which has been made to this honorable court, for the sake of convenience and better understanding, it can be divided into 4 parts. And my lord, the first part, whether the loss arising out of blacklisting is ascertainable or ascertained. This is the first question according to the reference made to the court. The second part is whether such loss falls within the ambit of section 21D of the Adhini. My lord, with the permission of the court, may I read it? My lord, the reference first.
Yes.
My lord, the reference which has been made to the honorable court is whether the loss arising out of blacklisting order can be ascertainable or ascertained and hence falls within the ambit of section 21D of the Adhiniam. If not, whether the full bench in Gauri Ganesh, Supra and division bench in Avasti Brothers Construction Company, Supra have correctly opined that against blacklisting order, also contractor has a remedy before the tribunal constituted under the Adhiniam. Second, if a composite petition and if a composite order of termination of contract and blacklisting is called in question in a writ petition and no remedy is available to the contractor against the blacklisting order, entertainable despite the availability of remedy against the termination of works contract under the Adhiniam for application for recalling of the personal source. So, my lord, I have divided it in 4 parts. This reference.
Yes.
So, my lord, I have divided this reference in 4 parts. Number 1, whether the loss arising out of blacklisting is ascertainable or is ascertained.
You have a written note, Mr. Chen?
My lord,
You have a written note.
my lord, I could not get it typed. I get it typed, my lord, and then
Tell us. What are the 4 propositions?
first is whether the loss arising out of blacklisting is ascertainable or is ascertained. Number 1. Number 2, whether such loss falls within the ambit of section 21D of the Adhiniam. Number 3, my lord, whether remedy.
Just a minute.
Sir.
आपके हाथ में नोट है और हमें लिख रहा है.
I should have get it typed and
नहीं कोई बात. Yes. Whether such loss falls within the ambit of
section 21D of the Adhiniam.
Yes.
Number 3, my lord, whether remedy against blacklisting is available before tribunal and whether judgment of Gauri Ganesh and Avasti Brothers laid down correct. This is the third division which I have made. And the fourth one is whether composite order of termination and blacklisting is challengeable in writ petition and whether reference to tribunal is an alternative remedy.
Let us complete the question.
Yes.
Now you are coming into the validity of blacklisting altogether.
No. Yes.
If it affects fundamental right to do business,
yes,
then you are challenging the power of blacklisting completely.
Not power, my lord, but the validity of the blacklisting order. Power is always rest with the authority to blacklist me. No dispute about it. But that power is legally exercised or arbitrarily exercised is a question is to be considered by the court is different.
But that will be a factual dispute, whether in facts of a particular case is rightly blacklisted or not.
So the point which I am making before your lordship is that the order of blacklisting is violating the fundamental right of a citizen under Article 19(1)(g) and Article 21. Therefore, in a writ petition, the court is entitled to entertain the writ petition and decide whether blacklisting was correct or not.
Mr. Jain,
that is the difference.
The fundamental power to blacklist, you could challenge on the anvil of 19(1)(g).
Yes, 19(1)(g).
You can't blacklist me because it affects my fundamental right. That will be amenable before a writ court. But if you say that there is power to blacklist, but in the given facts of a case it has been wrongly exercised, then 19(1)(g) doesn't come in. What comes in the factual dispute?
Lord, may I make a submission? Point which I am making before you, Lord. Blacklisting of a person affects his fundamental right under Article 19(1)(g) and Article 21. Therefore, a writ petition is maintainable, and in the writ petition, the court has the jurisdiction that I was rightly blacklisted or wrongly blacklisted. But my petition cannot be thrown out on the ground that you have an alternative remedy. This is the submission which I made. I may be successful before the court, I may not be successful before the court.
No, Mr. Jain,
My lord.
this is not an adversarial litigation.
Yes, ma'am.
There are certain questions framed which are.
Yes, ma'am. In that light only, I address this honorable
We
court.
can also frame.
And my lord, I will confine my argument to the question which is referred to your lordship. And I will not repeat any of the argument which my learned friend Mr. Agrawal has.
We may frame additional questions also.
Yes, ma'am.
If they emanate from the original question.
So in my Amal submission, the point for consideration before this honorable court is that despite there being an arbitral tribunal under the Madhyastha Madhyakarana Adhiniyam, if there is a question of blacklisting, whether the writ court can entertain a writ petition so far as blacklisting is concerned. This is my submission, my lord, and I'll substantiate it. And my lord, the another question at the same time, which requires your lordship's kind consideration. What are the powers of the tribunal under the Madhyastha Madhyakarana Adhiniyam? The power of the tribunal is confined to awarding compensation or damages or claim. Nothing more. And my lord, two questions may arise before your lordship. If a contract of the contractor is wrongly terminated, then under the Act and under the Specific Relief Act also, if the contract is not specifically enforceable, then the person can claim monetary compensation on the ground of damages. But if the contract is having a nature which can be specifically enforced and my contract is terminated, then I have no remedy except to come before the lordship under Article 226, making a prayer that the termination be quashed and my contract be restored. That power the tribunal doesn't have. The tribunal has only the power to award compensation or damages or claim. So we have to draw a fine distinction between two points. If my claim is that my contract could not have been terminated and it is liable to be restored, then I have to come before your lordship. But if I am claiming monetary claim for wrongful termination, then I have to go before it. Similarly, my lord, in case of blacklisting, there are 2 points. Number one, for quashment of blacklisting at the threshold. Secondly, my lord, having suffered blacklisting, I can claim compensation. So if I am claiming compensation, I have to go before the tribunal. That this honorable court will not do under Article 226.
Gauri Ganesh ne also kaha hai that you cannot segregate the two claims.
It can be, my lord, and my lord, with great respect, my lord. The Gauri Ganesh, in the Gauri Ganesh matter, my lord, the matter was not examined from this angle. It has merely said that it is a consequential relief which can be claimed in the reference under section 7. So, my lord, my humble submission is twofold. If I am seeking restoration of my contract which has been wrongly terminated, then the tribunal has no jurisdiction to decide that question. Number one. Number two, if I am coming before this honorable court against blacklisting order and to with a prayer for stay it immediately because I'll suffer, my lord, I have to come before your lordship. Simultaneously, if I am making a claim, monetary claim against blacklisting, then your lordship can always direct a contractor to go before the tribunal and get it quantified. And what?
In that situation, tribunal will decide the validity of the order of blacklisting. So when in first situation, why tribunal can't decide the validity of the?
I do agree with your lordship. I do agree.
Because in second situation,
My lord.
the tribunal will have to first decide whether you have been rightly blacklisted or not. Then the tribunal can grant you the compensation.
Yeah.
So meaning thereby tribunal is having a jurisdiction to decide the validity of a blacklisting order. Then simplicity order of blacklisting, why can't we refer to it?
I'll answer it. My lord, the power of blacklisting is not arising out of a contract. It is not arising out of a contract.
Not that they are done.
No, my lord. But
It's how they are in the
except fruit,
circumstances, you may be
blacklisted.
termination of contract. The contractor may be blacklisted.
You
Well,
only
submission
submission that you're presupposing that power of blacklisting is not part of the contract.
Yes,
But some contracts which we have been shown, there is a specific provision.
I'll cite a judgment, my lord. Where is this one?
We are not disputing, we are saying that there is another presupposition that blacklisting is not part of the contractual obligation. And you are proceeding on that presumption. But there is another fact that in some contracts, blacklisting is part of the contractual obligation. So therefore, you will be required to address us from two events,
Yes.
from the perspective of two eventualities.
Yes.
Where blacklisting is not part of the contractual obligation, and where blacklisting is part of the
Part of the-
contractual obligation.
I'll address to this. Well, first, when there is no stipulation or clause in the contract for blacklisting, then it is not a part of the contract. In some of the contracts, I cited 2025 judgment of the Honorable Supreme Court where it was a part of the contract. And my lord, in case where there is a stipulation in the agreement itself that your contract can be terminated in case of breach and you can be blacklisted also. So the point which I am making before your lordship, even if there is a stipulation in the contract, the authorities cannot be allowed to apply it arbitrarily or illegally. And whether such power has been exercised arbitrarily or illegally, it is always subject to judicial review. And the power of judicial review lies with the High Court under Article 226. That power does not lie with the tribunal, my lord. And I cited recent judgment of this of the Honorable.
Tribunal can only award compensation, not
Yes.
remove the stigma.
Yes. And my lord,
Declare that blacklisting is illegal.
and my lord, the next question which I want to
Judgment on the site कर रहे हैं। 2025 का judgment।
my lord, I have uploaded it on ERP also. I'll cite, and my lord, the another question, which is the very basis of the reference made to this honorable bench, is whether an stigma and the question relating to reputation, defamation, and other, like, whether the loss arising out of it can be quantified or ascertained. And in my humble submission, my lord, it can never be. Any amount of compensation would not remove the stigma which has been casted against me, or I am defamed in public or in the business community. It is only a solace that yes, you have suffered that we cannot reverse the clock. Therefore, we are granting you the compensation. Whether my reputation can be restored back.
नहीं, देखिए इसको इस एग्जांपल को बहुत दूर मत ले जाइए। In a case of prevention of corruption act, somebody is held guilty by the trial court.
Yes.
Now that person happens to be acquitted by the High Court or
My
the
lord.
Supreme Court as the case may be.
My lord.
Now that stigma which has been attached to this character by virtue of the conviction by the trial court
My lord.
cannot be washed away merely on account of acquittal.
My lord.
Now there is a remedy provided under the law to claim damages for malicious prosecution.
My lord.
Right? So if we allow ourselves to intermix this issue,
My lord.
removal of stigma, then we will be somewhere straying away from our
My lord.
basic task. So let us confine ourselves to
Yes, sir.
presupposition
Yes.
that the order of blacklisting is as a consequence of termination of the contract, and whether that is ascertainable or ascertained amount which can be referred to the tribunal or not.
My lord, my very humble submission before your lordship is the loss suffered because of blacklisting is neither ascertained nor is ascertained. And my lord, to illustrate it, if your lordship permits me, my lord, if I am losing my son, my daughter, or my bike in a motor accident, any amount of compensation can be sufficient to the loss which I have suffered. But in such cases, when it is not possible
You
for
take a contract or work to earn money,
yes, my lord,
but you can't have a relationship, son and daughter, for money purpose.
my lord, the submission
Compare that contract with
my lord,
that relationship.
मैं आपसे जो निवेदन करना वो मैं ये निवेदन करना कि ये मैं आपको जजमेंट मतलब ब्लैक लिस्टिंग अमाउंट्स टू ए सिविल डेट that has been held by the honorable supreme
Broadcast it is.
yes and in Kulja case of Jharkhand also. What can the court do is, my lord, the court cannot reverse the clock. Therefore, by way of compensation, yes, you are entitled to this much. But the loss which I have already suffered cannot be restored back. And so far as the query raised by Honorable Justice Agarwal, if I have been prosecuted under the PC Act and I am convicted.
This is not a query, it is just an observation.
Yes, ma'am.
It's a passing observation.
Yes,
Nothing.
but the question remains before your lordship is that before adjudication of my guilt, if I am punished, then it is impermissible. And what I want to submit before your lordship is that the termination, if it is upheld by the tribunal, then I can be blacklisted also. But there is no adjudication. An adversary is taking a decision that you have committed a wrong, your agreement is terminated, and you are blacklisted also. So this is a punishment before adjudication.
That can be a ground.
This is and by that time the reference is decided. I would already suffer, my lord. And my lord, the submission which I am making is, says your lordship has observed that in all government contracts there is a condition which requires a declaration from the bidder that whether you have ever blacklisted. If my answer is yes, then the contract would not be awarded. So this is one thing, my lord. And my lord, similarly, my lord, even in the society, if there is an stigma on me, society may not choose to deal with me. So this is a serious consequence in my humble submission. So the loss suffered because of blacklisting, that amounts to a civil debt, can never be compensated in terms of. And it cannot be restored back also. Therefore, in cases of so-called notice for blacklisting, we are coming before your lordship, and your lordship, in the given facts and circumstances, granting stay also. And ultimately, your lordship find that the principles of natural justice are not followed, and there is no circumstance to blacklist him. Your lordship setting aside. Therefore, my lord, in my humble submission, in case of an action of blacklisting only, where I am not claiming any monetary relief, then only the Honorable High Court has the jurisdiction under Article 226 because it is affecting my fundamental rights. And any alternative remedy of getting compensation is not an efficacious alternative remedy on which ground I can be thrown out. Next point. Next one. Then, my lord, the termination of contract and blacklisting are two separate things. In all cases of termination of contract, there is no need of blacklisting the contract. It is neither necessary nor consequential. And my lord, the Supreme Court has laid down the guideline under which the blacklisting can be. There should be an element of cheating, fraud, misrepresentation. Well, public at large is likely to adversely suffer. These are the conditions for blacklisting. Mere breach of contract is.
Which judgment are you relying upon?
And my lord, with the permission of the court, I may come to judgment little later, just to with the permission of. So, my lord, the point is that the termination of contract and blacklisting are totally two different things and independent to each other. Number two, my lord, the blacklisting is not a necessary consequence of, in all cases, of breach of contract. And the third point which I want to raise before, ex parte termination of contract is not final and it is subject to judicial adjudication by the tribunal or arbitrator or the court. Hence, my lord, the blacklisting must be preceded by following point, my lord, termination and termination of on the ground of breach of contract is finally adjudicated to be legal. Number one. Number two, my lord, breach of contract must have element of intentional cheating, fraud, causing intention to loss to the public at large, and blacklisting is necessary to save the public institutions from the loss while dealing with such scrupulous contractors. This is the purpose of blacklisting.
Decide हो जाएगा. Court में decide हो जाएगा.
That my lord can always call upon the authority that on what ground you want to blacklist him. And if these elements are absent, your lordship can certainly set aside it. And my lord, doctrine of proportionality can also be examined by this honorable court. That in the given facts and circumstances, blacklisting was necessary or not. They can always be examined by this honorable court in my mind. And my lord, as I have already said that the blacklisting is an independent process. And my lord, what is the immediate remedy available to such a person who has suffered an order of blacklisting? My lord, the tribunal under section 17 cannot grant any interim delay. So first of all, I am made to suffer that order. and then claim compensation. And in cases of irreparable loss or injury in civil suits, in writ petition, this honorable court is granting interim relief. And that power is not does not lie with the criminal matter like section 9 in the Arbitration and Conciliation Act.
हमारा 17 AD
So the question is the person cannot be left remediless and first to suffer and then claim compensation. And my lord, in such a writ petition, three courses are open for the High Court. Number one, the court can say that yes, your blacklisting will remain in abeyance till the point of termination and everything is decided by the court. This court can say without deciding the number one. Number two, this court can set aside the blacklisting order without granting any monetary compensation. Number three, for monetary compensation, this court can direct me to go to the tribunal and claim monetary. And in substance, the question of blacklisting and the remedy against the blacklisting order without monetary relief and without any further relief is totally within the domain of this honorable court under Article 226. Then, my lord, the question of arbitrability has been argued by Mr. Amit Oga, so I will not repeat it. And I just support him that the question of blacklisting is not arbitrable by the either by the arbitrator or by the arbitral tribunal also. Then, my lord,
1 minute.
sir, the claim towards the loss of compensation is not a consequential relief. What has been said in the full bench judgment of Gauri Ganesh that it is a consequential relief, my lord, I respectfully submit that it is not a consequential relief is when in the absence of such relief, the main relief cannot be granted. Then it is a consequential relief. Section 34 of the Specific Relief Act deals with the declaratory suit. If I am filing a simple suit for declaration and I am not in possession of the property without seeking the possession, the court will say that you have not sought the consequential and necessary relief, therefore main relief cannot be granted.
Mr. Jain,
My lord.
say a contractor is blacklisted.
Yes, my lord.
He is blacklisted for a period of 2 years.
My lord.
Immediately on day one, he approaches, he initiates his remedy. There is no loss suffered
Yes, my lord.
and blacklisting is set aside.
My lord.
So where is the question of blacklisting not being a claim of loss of business, not being a consequence of blacklisting?
Yes. I have a simple reply to it. If I have been served with a blacklisting order today and I am coming before your lordship tomorrow and your lordship stays it, then I have not suffered anything. So I cannot raise any monetary claim because your lordship has protected. The question of monetary loss on account of blacklisting would only arise if I have already suffered that order. And the point is, since I am entitled or legally entitled to claim monetary compensation for blacklisting, I cannot be thrown out of the court that, yes, my lord, I am going to suffer this order or I am suffering, it may kindly be stayed. And my lord, in the cases your lordship...
that stay will operate against the respondent only.
Yes, my lord.
Other ABCD companies or state may say we are not party, then that is.
I do agree, my lord. But if your lordship has stayed that blacklisting order, then it is not final
Level.
and that bar will not come in my favor because it has been stayed by the honorable high.
That matter is sub judice.
Matter is sub judice. And the point is, my lord, in cases of irreparable injury which is going to cause to a person, the immediate relief is necessary, my lord. The person cannot be left remediless. And in the cases, my lord, your lordship has come across where a defamatory publication is made by the media or in the newspapers, my lord. Then the petitions are filed with a prayer that they be restrained from making further publication. And your lordship is granting relief. Your lordship is not throwing out the petitioner. Well, yes, it has not been published. If you suffer, you can claim monetary compensation. And my lord, therefore, in my humble submission, my lord, so far as only the blacklisting part is concerned, without any monetary relief, only the writ petition is maintainable. And my lord, a supplementary question is when a contractor is claiming restoration of his contract, then also this honorable court has the power and the tribunal has no power. Because tribunal can only award compensation. It cannot restore back the contract. even if it was illegally terminated. And for this limited purpose, my lord, I want to rely on 4 judgments which are. And I'll start from the latest one, my lord.
Technoprint.
Latest one is, my lord.
Technoprint. Technoprint.
Yes.
43.
I have uploaded it.
Yes, 43.
UMC Technologies.
Yes, ma'am.
Technoprint. Yes.
Technoprint.
Technoprint. It is Technoprint. Justice Party wala chahiye.
Yes, ma'am.
What platform is it?
Hello?
43 number.
On the first,
Reference.
there are different, there are 2 sections.
What a 44.
To save the time, my lord, I'll
30. 43.
What is the UMC Technologies?
no, 43.
Technoprint versus Chhattisgarh.
Yes, ma'am.
38.
Serial number 43.
Serial number
No,
30.
there
One
are
list.
different, there are 2 sections, upper and the lower section.
Second section 30 number.
This is
This section by
SEC online version,
Yes, ma'am. Yes.
43 in the other one.
30 पे भी है।
दो है सर, एक वकील द्वारा एक
हाँ उसमें 30 पर है। लॉयर्स वाले में
लॉयर्स वाले में 43 पे है।
Lawyers वाले में 43. Yes,
रिटर्न बाय रिटर्न 30 number.
yes, ma'am.
Yes.
May I read it?
हाँ, पैरा
Para 18, my lord. I am directly coming to para 18.
मेरा 16 देखेंगे।
Yes, ma'am. It is true that ordinarily a writ in any petition seeking to challenge a so-called notice, because, my lord, in that case, the so-called notice was challenged.
Notice was checked under check.
And the Supreme Court has said, yes, it can be done. It can be challenged. And it has been struck down. So-called notice, unless the court is convinced
Where are you
that
reading?
मेरा 16.
para 16, my lord has ordered me to take it.
16.
it is true.
It is true that ordinarily a writ court should not entertain any petition seeking to challenge a so-called notice unless the court is convinced that the same has been issued by an authority having no jurisdiction or the same is tainted with malafide.
These are two. In these two eventualities, the report limited.
So-called notice case.
So,
And, my lord, perhaps in this present case, my lord, the blacklisting for final order has been passed. I'm not aware.
The facts of this case.
And, my lord, even then this so-called notice can be interfered. My lord, paragraph 18. The aforesaid at best could be said to be a case of breach of contract. The only point is whether such a breach of contract would entail the consequences of getting blacklisted. Then, my lord, I'll directly come to paragraph number 25. This court in, may I read it, ma'am? May I read it?
Page 22.
This court in Kurja Industries Limited versus Chief General Manager, Western Telecom Project BSNL in so and so has made a pertinent observation as regard the power of an authority to blacklist a company on the basis of the terms of the underlying contract. In case of Kurja Industries, contractor was blacklisted by BSNL on the allegation of having obtained fraudulent payments from the authority. This court in the said case set aside the order of blacklisting passed by the authority as it has the effect of permanently affecting the business of the contractor. This court identified the limits of powers of a statutory authority to take coercive action against companies. The court, after examining the terms and conditions prescribed in the tender document relating to disqualification and blacklisting, observed that the power to disqualify a contractor was provided for in the tender document, and such power could be read as an inherent power. And in the terms of the same, the authority would have to show that the supplier A habitually failed to supply the equipment in time, B the equipment supplied by the supplier did not perform the satisfactorily, or were not of a particular standard, or C failed to honor the bid without sufficient grounds. And, my lord, in paragraph 27, again, my lord, relying upon a earlier judgment in Blue Deems Advertising Private Limited, my lord, the conditions which has been laid down by the Supreme Court, that in case exists a genuine dispute between the parties based on the terms of contract, blacklisting as a penalty cannot be imposed. 2. The penalty of blacklisting may only be imposed when it is necessary to safeguard the public interest from irresponsible and dishonest contractors. 3. The corporation, being a statutory body, have a higher threshold to satisfy before passing such blacklisting order, and therefore the measures undertaken by it should be reasonable. Then, my lord, paragraph 28. Again, the aforesaid decision of the court was rendered in case. Then, my lord, I am coming to paragraph 32, which according to me, 32 and we may put it straightly different way. This is 31. To put by way of an illustration, the police has the power to arrest, but it is not necessary that in all cases arrest must be effected. The police should know whether at all arrest is necessary. We may put it in a slightly different way. Take an instance, the so-called notice in the present case is the final order of blacklisting. The final order in any case cannot travel beyond the so-called notice. Therefore, we take the so-called notice as the final order. Whether it makes out a case of blacklisting, this should be the test to determine whether it is a genuine case of blacklist a contractor or visit him with any other penalty like forfeiture of EMD, recovery of damages, etc. We say so because once an order of blacklisting is passed, the same would put an end to the business of the person concerned. It has a drastic step. Once the final order of blacklisting, the contractor is passed, then the contractor is left with no other option but to go to the High Court. This is important.
But in this case, there was no such issue that there is a tribunal constituted under the state act. For the purpose
rather your lordship
between the contractor and the principal.
Rather, your lordship is referring that there may not be any arbitration clause.
Was not involved because no such either in the case of Vidya and rather in the case of the Blue Dream or in the case of this Technoprint. This was not directly involved.
Manoj, in one of the cases, the claim before the arbitration has already been filed and blacklisting order purchased. I'll just point out from the judgment.
This is a case of Chhattisgarh where the tribunal is there.
Yes, ma'am.
But Technoprints will not be covered because it's a work
It is not a work.
It's not a
It's not a work contract.
Manoj,
that issue was not.
Manoj, the question of works contract or simple contract will not, if in the contract, if there is an arbitration clause, Manoj, the works contract, so far as the under the act is concerned, that even if there is no arbitration clause in the agreement, then you have to statutorily go in the arbitration. So the point is that the arbitration in a arbitration clause in a works contract is inherently incorporated in the agreement by virtue of the. So if there is an arbitration clause,
Impliedly
incorporated. I do agree. So the point is, even if there is an arbitration agreement or the remedy of statutory arbitration, still the question of blacklisting can be examined only by the High Court.
This was the case against the show cause.
Yes,
And no party has invoked the arbitration clause.
even
If the party has invoked the arbitration clause, then the remedy
my lord, the
to
submission,
challenge the show cause.
my lord, the submission, I do agree with your lordship, my lord. In
Approaching to this statutory tribunal is concerned, there is
My lord,
invoke the clause.
I do agree with your lordship's observation, but the question which I am raising to myself, my contract is terminated on 1st, and I am blacklisted on 1st, and I am coming
to
with
challenge the show cause notice. Then we can consider the argument that for the purpose of challenging the show cause notice,
my lord.
as there is no alternate remedies available,
Yes.
then the only forum is 236.
Yes.
But we are dealing a case where there is an order of blacklisting has already been passed. There is an order of the termination, and under that circumstances, which will be the forum.
My lord, I have already explained it, my lord. The tribunal can only award compensation for the loss of blacklisting. The stigma, the question,
of the legality of blacklisting.
my lord, it will decide while awarding the compensation. But the question is that if I want a immediate relief to prevent the sufferance or possible irreparable loss, then where is the remedy available to me?
But it doesn't mean that final adjudication will also by the High Court. You will approach to the High Court that
ये तो मैंने कहा ना कि हाई कोर्ट के सामने 3 ऑप्शन अवेलेबल है.
the tribunal, which is having a jurisdiction to deal with, take decide the
Yes,
issue,
ma'am.
is not having any jurisdiction to grant interim relief. A party may approach as it is decided by the Vivi Verma's case and Tulsi Narayan Gar's case,
Yes, ma'am.
that for the purpose of granting of interim relief,
Yes.
entertain our
My lord, at the if your lordship may recollect, at the threshold I have said, my lord, if a blacklisting is ordered challenged before the High Court has 3 options. One, they can say that this order of blacklisting shall remain against if the reference is decided. Number 1. Number 2, if apparently the High Court is of the opinion that this order of blacklisting is wholly illegal, arbitrary, unsustainable, the High Court will set aside that order. And number 3, if any person want to claim any monetary compensation, then he has to go before the tribunal. Uske High Court will not decide the monetary compensation.
if someone is interested to challenge the order of blacklisting,
My lord.
with a relief of compensation,
My lord.
then the remedy is with it.
No, my lord. No.
Blacklisting.
My lord, in that case, the High Court will bifurcate the relief. Yes, so far as the question of declaration of blacklisting is concerned, we'll consider, and so far what would be the amount of compensation will be decided by the tribunal. My lord.
राइटर साइड आप ये कह रहे हैं जब तक वो हाई कोर्ट में वकील साहब को टोल टैक्स नहीं देगा तब तक ट्राइब्यूनल नहीं जा सकता.
And my lord, the submission which Mr. Agrawal has also argued. Read only two paragraphs from the judgment, my lord,
Yes.
paragraph number 32 and 33. We may put in a slightly different way. EMD recovery, it is a drastic step. Once the final order of blacklisting of the contractor is passed, then the contractor is left with no other option but to go to the High Court, invoking the jurisdiction under Article 226 of the Constitution and challenge the same. If he succeeds before the single judge, then it is well and good. Otherwise, he may have to prefer a writ appeal or LP as the case may be, and this again would be lead to unnecessary litigation in the High Court. The endeavor should be curtailed, and I'm skipping it.
ये पहले जो उसको relevant है वो.
अच्छा, पढ़ते थे?
Why this case was intervened?
Yes, sir. This again would lead to unnecessary litigation in the High Court. The endeavor should be made, should be to curtail the litigation and not to overburden the High Courts with the litigation of the present type, more particularly when the law by and large is very well settled and there is no further scope of debate. And my lord, if the law is well settled by the Honorable Supreme Court, Honorable High Court, and the authorities are not following it and passing an order of blacklisting, then what is the remedy? Therefore, the Supreme Court has said that the authorities should be careful while passing the blacklisting order. As observed by this court in Eurasian Equipment and Chemical Limited, State of West Bengal, an order of blacklisting casts a slur on the party being blacklisted and is stigmatic. Given the nature of such an order and import thereof, it would be unreasonable and arbitrary to visit every contractor who is in breach of his contractual obligations with such consequences. There have to be a strong, independent and overwhelming material to resort to this power given the drastic consequences that an order of blacklisting has on a contractor. The power to blacklist cannot be resorted to when the ground for the same are only breach or violation of the terms of or conditions of a particular contract, and when the legal redress is available to both the parties. Else, for every breach or violation, though there are legal modes of redress and which compensate the party like a corporation before us, it would be resort to blacklisting at the times by abandoning or splitting the pending legal proceedings. In this case, my lord, I am open to correction. The arbitration proceedings were pending. Then, my lord, the another judgment.
That will continue, Mr. Jain, after lunch.
My lord,
After continue after lunch.
I am deeply.